Mr. Green, can I raise two housekeeping points? The first is you asked at the beginning of your address for some guidance about other issues apart from the one you're dealing with at the moment. The Lordships would find it convenient if you dealt with the question of the correct remedy and also with the scope of the discretion under section 212, which I think are things on which you appeal, having lost below. There are other issues which Mr. Knox will develop in his appeal, which are best left over, I think, until we've heard from him. Does that assist?
Certainly. Does that mean you don't wish me to deal with, at this stage, strict or fault liability?
Well,
it does, to a certain extent, lead into...
Yeah, I suppose it leads into the correct remedy.
Maybe we can work out when I get
certainly on those issues that you were successful on, which Mr. Knox wishes to open up, I think we'll wait until we've heard from Mr. Knox on those points. The second point affects everybody. The Lordships would find it convenient if we were to rise at 3:30 tomorrow rather than 4 o'clock. I don't know how we're doing on time, but it might be sensible if we were to sit at 10 o'clock rather than 10:30 tomorrow. Would that be convenient? That would be very helpful from our point of view. That's on the understanding we would have to finish at 3:30.
Yes, of course.
Thank you very much.
There were a couple of factual matters that my Lord Walker raised right at the beginning, which perhaps I can just deal with quickly. First of all, the issue concerning the shares and the classes of shares, and whether more than one share in each class was issued to each consultant shareholder. We don't know the exact position, but of course there could have been more than one share in each class issued to the same person. But of course the affairs were arranged so that there were not too many people in each composite company so that the threshold would be threatened. That must have been the case. Secondly, as to whether some were paid purely by way of salary, it is correct that there were some who were suspected of being IR35, within IR35, who were employed on a full salary in order to deal with that.
It may be not all the members of the court know about IR35, but I don't think we need to start going into that. I only know about it because I happened to write a judgment on it when I was in the Court of Appeal, when it was challenged by way of judicial review in 2001.
Well, as your Lordship will be aware, of course, the Revenue are quite concerned about the employment structures in these sorts of cases. And in fact, this sort of structure is now not allowed under current legislation. There can't be this payment of dividends in this way since 2007. And indeed, as we understand it, the paycheck companies, as they exist currently, are operating by way of a salary, some sort of salary scheme, all on PAYE, therefore. My Lords, the only final point concerns the dormant accounts of the paycheck directors. Yeah. And apparently it means when dormant accounts are filed that there have been no accounting transactions as such taking place within the company. But it doesn't mean that it's not doing anything. Now, my Lords, going back to where I was at, can I clarify one matter in relation to the duty that we say the director or de facto director is under in this respect? And we spell it out in paragraph 69 of the case, that a director is under an absolute duty not to cause his company to make ultra vires payments and not to act outside the company's constitution. The payment of an unlawful dividend is an ultra vires misapplication of a company's capital. And there's a reference to, I don't think we need to go to it, to Claridge's Patent Asphalt Company, in which Mr. Justice Asprey said, all applications of a company's money ultra vires the company are in fact breaches of trust on the part of the directors. So that is the broad duty that we would submit a director is under in this context. And whether or not that person is a de jure director or a de facto director, it is an inescapable duty to which he is subject. Now, my lords, I've dealt with the second objection that we've misstated the rationale of de facto directorship. I would just say finally in relation to that, the implications of the Court of Appeal's judgment, as I've already submitted, are very broad, and it would lead to structures being perfectly legitimate, avoiding liability and potential disqualification. But the implications of our formulation, in which capacity is not relevant and it can be ignored in determining de facto directorship, do not lead to any problems. I mean, there may be particular factual issues to be sorted out in a particular case, but those are issues that are resolved day in, day out by first instance judges deciding de facto directorship. But to say, as we suggest, that one can ignore capacity when deciding issues of de facto directorship is a simple and easy answer to the question that's posed by this appeal. My lords, the third objection is this corporate veil, that we are seeking to effectively pierce the corporate veil. I've really dealt with that by reference to my submissions on Pakistan National Shipping, and the point is that this is nothing to do with corporate veil. What is the corporate veil that we are said to be trying to pierce? We are not suggesting that a director of a corporate director is per se a de facto director of the subject company. See Mrs. Holland. The corporate veil adds nothing to their case because, as I've also already submitted, the same must logically follow if a natural person was the de jure director of the composite companies, and Mr. Holland was acting in the same way pursuant to some sort of contract or arrangement with that de jure director. The fact that Paycheck Directors is a company is completely irrelevant. The fourth objection is the long exegesis by my learned friends on the analogous situation, they say, concerning directors of corporate trustees. And there are a number of cases referred to. In our submission, those cases are broadly inconclusive on the point. They certainly do not go as far as is suggested by my learned friends in their case. And it is not particularly analogous because the de facto concept has not really developed or been argued in that world, the trustee world. There's no real equivalent of a de facto director in trust law, and there are important distinctions between the position of trustees and directors. But, my lords, in any event, on close analysis of those authorities, they only actually decide what Lord Millett decided in Re Hydrodam, and are indeed consistent with the position that we are advancing, namely that directors of corporate trustees are not merely by virtue of their position as such subject to fiduciary duties to the underlying beneficiaries. If they do more, they may become so, and whether a person is subject to fiduciary duties or disabilities depends crucially on the facts and the knowledge of the individuals concerned. Furthermore, the authorities support our distinction between voluntarily assumed duties and duties imposed by law. That distinction is made in the authorities. So, my Lords, I don't think I would propose to go through all of the authorities that are cited by my learned friends, just two of them, and they are consistent. The others are consistent with my submissions in relation to them. Of course, the main case is the case of Bath and Standard Land Company, which is the one that is relied upon in the later Australian cases and the first instance decisions of Mr. Justice Lindsay.
This is paragraph 42 of the respondent's case, I think I'm right in saying.
It is, my Lord. But they refer to the case of Wilson and Lord Berry, which rather than taking your Lordships to the actual authority, you can see the quote, the first quote that they have there from the judgment of Lord Justice Brett, as the agent of an agent is not thereby the agent of the original principal, so neither the agent or trustee of a trustee thereby the trustee of the original Setica Trust. That's the same point. We say it's not merely by virtue of his position as such does he become liable to the third party.
Yeah, that's the Mrs. Holland point, basically, isn't it?
Correct, exactly. Now, Bath is in volume 1, tab 7. And in Bath, there was the majority view in the Court of Appeal was that there was no fiduciary relationship between the directors of the corporate trustee and the underlying beneficiaries. But there is a strong dissenting judgment from Lord Justice Fletcher Moulton, which raises quite a number of the issues before your Lordships today, and which I would wish to show your Lordship. But the important point to mention in relation to his dissent is that he considered that on the facts there was sufficient to give rise to a fiduciary relationship. So whereas the others did not consider that there was on the facts sufficient to give rise to a fiduciary relationship. It doesn't affect the point that we extract from this case, namely that it is only that there has to be something more than merely being the director of the corporate trustee or corporate director. Just looking first at the judgment of the Master of the Rolls. At the bottom of page 625, he says, directors stand in a fiduciary relation to the company, but not to a stranger with whom the company is dealing. It is, of course, true that a company acts through its directors, but that does not involve the proposition that if a breach of trust is committed by a company acting through its board, a beneficiary can maintain any action against the directors in respect of such breach of trust. Of course, I accept the case where trust property can be followed into the hands of a director or of any stranger with notice. And then over the page, on page 627, at the bottom of the page, after the reference to Powell and Thomas and Evan Jones, about 10 lines up from the bottom, the Master of the Rolls says, I base my decision upon the broad principle that directors stand in a fiduciary position only to the company, not to creditors of the company, not even individual shareholders of the company, still less to strangers dealing with the company. This principle applies equally whether the relation between the company and the stranger is one purely of contract, such as principal and agent, or is one of trustee and Setica Trust. To speak of directors as the brains of the company or the hands of the company is only to use words which have no definite meaning in this connection. So that states the broad proposition, and Lord Justice Buckley, who agreed with the Master of the Rolls, made it clear how far they were going on page 642. And if your lordships could look about near the middle of the page, 642, where he says this conclusion is rested upon the proposition that the directors stand in a fiduciary position towards Mr. Bath. In my opinion, this is erroneous. A fiduciary relation can only arise either contractually or by implication of law. The contract between Mr. Bath and the corporation is one to which the directors are not parties. No one could contend that a director is in any way liable upon or in respect of the contract of the corporation. Between Mr. Bath and the directors there exists no privity of contract. Then does there arise, as between those parties, any fiduciary relation by implication of law? I think not. Under circumstances such a relation might arise by implication of law. The facts here do not raise it. So he's not ruling out the possibility that if the facts were sufficient to raise a fiduciary relationship between the director of the corporate trustee and the underlying beneficiary, that could happen. So there's certainly no suggestion that capacity as such, he being a director, the corporate director, would rule that out. And that point is repeated on the last page, page 647, about 12 lines up from the end, when Lord Justice Buckley says, but a declaration that the remuneration is to be disallowed on the mere ground that the recipient was a director is, in my judgment, erroneous. So that was the issue they were deciding, and in our submission that is the only ratio from that case.
I mean, it's not in dispute, is it, that if Mr. Holland were a de facto director, then he would owe duties.
Absolutely.
Yeah.
That's really the issue.
Yeah, I follow that.
If he, yes. And looking at Lord Justice Fletcher Moulton's dissenting judgment, first of all on page 633, the paragraph in the middle of the page, it is needless to say that propositions of so wide a character are those contended for by the appellant can be established. The declaration appealed against is wholly wrong. In my opinion, they cannot be established. There is, in my opinion, a fundamental fallacy in the whole of the argument addressed to us by counsel for the appellant on this part of the case. So they've confounded the proposition that a man does not come into fiduciary relations with the Setika Trust merely by becoming an agent of the trustee, a proposition of undoubted validity, with the proposition that an agent to the trustee cannot stand in a fiduciary relation to the Setika Trust. This is, to my mind, as grave an error as for a criminal lawyer to maintain the proposition that a fact that is not sufficient to secure conviction is sufficient to necessitate an acquittal. In order to establish a fiduciary relation between the Setika Trust and an agent of the trustee, you must look at the facts of the case and see whether they establish such a relationship. That is exactly what we say should happen in relation to de facto directorship. It is impossible to say generally whether an agent of a trustee is in a fiduciary relation to the Setika Trust, but it is not only possible, but correct, to say that if nothing is present, but the fact that he's an agent of the trustee, that alone does not suffice to make him responsible to the Setika Trust. In such matters, a man's responsibilities depend on the acts which he does and the knowledge that he possesses at the time when he does them. This is true whether a man be an agent of a trustee or not. His being such agent does not shelter him from the responsibilities flowing from the knowledge he actually possesses, whether that knowledge has come to him by virtue of his position or aliunde. If it is such that it would suffice to make a third person liable to the Setika Trust for the acts done by him, his being an agent to the trustee is no defence against his being held to be so liable. Well, my lords, that fully encapsulates our submissions to your lordship about de facto directorship and capacity. And Lord Justice Fletcher Moulton is clearly saying that acting on behalf of a corporate trustee does not provide any sort of shelter from the responsibilities flowing from his position and his acts. It depends on the actual acts. And finally, on page 636, at the middle of the page, the simple question is whether where a limited company undertakes the administration of a trust, the directors as individuals may come under a duty to the Setica Trust, if so, under what circumstances, to what extent. First place, I'm of the opinion that although directors of a company are properly described as its agents and act as such, there's a broad distinction of degree between them and ordinary agents, which is of importance in deciding such a question as this. Is that so far as knowledge and intention are concerned, the company is an abstraction. Where directors actually perform their part in the management of the company, they are both the brains and hands of the company, and they cannot shelter themselves under the plea that the knowledge of the trustee is not their knowledge, or that the nature and intention of the acts of the trustee were unknown to them. Again, that's an important part. And then going over the page, the top of page 637, they have complete and perfect knowledge of the nature of the acts which the company is doing through them. They have even more than this. They know that there's no mind interposed between them and the Setica Trust, which administers the trust. It's they who are in fact doing it and no one else, although it may be done in the name of the company. So you can transpose into there, my lords, the name of paycheck directors. Now, I do not think it would be in accordance with the principles of equity to hold that these considerations make them liable for all breaches of trust on the part of the company, even though such breaches of trust were planned and carried out by themselves. The contractual liability of carrying out the trust is undertaken by the company, and it may involve responsibilities of a serious kind depending on a right construction of their powers and duties. Honest error in such matters might well render the company liable in the same way as it would be liable for negligence, but the directors would not be liable in respect of such matters. I might interpose there to say that in the respondent's case, the somewhat misleading quote from this judgment in paragraph 48 of the case, so they just refer to that sentence. That sentence, starting honest error, is clearly referring to contractual liabilities, not fiduciary. In any event, it carries on, but in my opinion, they are liable for matters of personal conduct inconsistent with their full knowledge of the fiduciary character of the duties which, in the name of the company, they have to carry out. First and foremost, amongst such matters of personal conduct stands the making of personal profit. That is a matter, the responsibility for which no man can place on the shoulders of another. It's an act for which he alone is responsible. So, my lords, this is the main case. This is the case upon which the later authorities are said to depend.
What do you get out of those passages?
Which part? The last.
That page 637.
We get out of that although the contractual, if the directors of the corporate trustee would not be liable for contractual liabilities of the corporate trustee, because those are voluntarily assumed duties by the corporate trustee, and its agent would not be liable for its contracts. But where one is in the area of fiduciary relationships and a direct fiduciary duty as between the director and the underlying beneficiary, then the involvement of the company is irrelevant. One is looking at whether by what the director of the corporate trustee has done in relation to the underlying beneficiary and his knowledge, whether he has done sufficient to become subject to fiduciary duties and fiduciary disabilities. In fact, this case was about whether they were allowed to profit from the trust.
I think this is a point that was touched on a number of occasions this morning, wasn't it? That you need to look very closely at what the basis of the liability is.
Yes.
And in this case, we're looking at, in effect, a statutory prohibition against paying out dividends in the situation that arose.
Well, we're talking, in my submission, about fiduciary duties.
Yes.
Fiduciary duties that inescapably arise for a director. But in this case, we're also looking at fiduciary duties, but fiduciary duties arising from a trust relationship. because the difference between these cases and ours is that one has to assume that the subject company is actually are the beneficiaries under this trust. That's as I understand the reason that this analogous situation is being put forward. And we say, well, similarly to that situation, a fiduciary duty arises as between a de facto director and the subject company because of what he does, because of the way he has acted in relation to the subject company. And we submit that Lord Justice Fletcher Moulton summarises very well the position. I say it's a dissenting judgment, but that is only really on the underlying facts. He thought there was sufficient to constitute a fiduciary relationship with the beneficiaries. So, my lords, this case has then been looked at through a number. First of all, a couple of Australian authorities, but if your lordship were to look at them carefully, it's clear that they don't say anything more other than the law is uncertain in this respect. So I don't think much is to be gained by.
So what's uncertain about the law?
They say it's uncertain when and how or if a duty would arise in this situation for a director of a corporate trustee.
I think the phrase used, and I'm looking at paragraph 51 in the respondent's case, is that the law is not fully developed.
The law, exactly, my lord, yes. In fact, that quote in paragraph 51 of the case is also somewhat misleadingly taken out of context. But I don't. If your lordships would like, I can take your lordships to that judgment. But I think it might be better to see if what my learned friend gets out of it any more than that. The second Australian case is ASN nominees, and perhaps I'll just take. Well, in fact, if your lordships are looking at the respondent's case rather than taking out the actual judgment, I can just show your lordships in the quote in paragraph 52 from there. At the end of that first paragraph, it says it's not open to doubt the particular factual relationship existing between a or the directors of a trustee company and a beneficiary or beneficiaries of a trust may properly warrant the finding of fiduciary relationship between them. But to say this is not to say that there is anything fiduciary in the trust company director-trust beneficiary relationship as such. And those words as such, we submit, are crucial. It doesn't follow necessarily as a matter of course. The decision of Mr. Justice Lindsay that I think Lord Walker was referring to this morning is the HR and JAPT case, which is referred to in paragraph 54 onwards in the case. And perhaps we could just have a look at that in volume 2, tab 17. And this was a strikeout application. The case has been put in a number of different ways as to why the directors of the corporate trustee, it's a corporate trustee of a pension fund, pension scheme. There are a number of ways in which the claimants sought to make the directors of that corporate trustee liable. And the first one was by reference to a direct fiduciary duty. And Mr. Justice Lindsay starts the discussion of this. The page numbers in the bottom right and left-hand corner of the page 129. I don't have paragraph numbers in here, although there are paragraph numbers referred to in the respondent's case. He goes through the various cases on fiduciary duty, including in particular Bath, which starts on page 130 at letter E, and the quotes from those judgments I've taken the Lordships to.
Yes.
And he refers on page 131 at letter D to Lord Justice Fletcher Moulton's powerful dissent. And then at letter F on page 131, he says, I am of course not able to prefer the judgment of Lord Justice Fletcher Moulton unless I can find there is some distinction or later authority that frees me to do so. Subject to that, I regard myself as bound as a matter of ratio by the majority view that directors, even of a trustee company, are not as such and without more in a fiduciary position in relation to the beneficiaries of a trust of which their company is trustee. So that is exactly the hydrodam Mr. Justice Millett position. As such and without more. And that is as far as it goes. We can see that obviously there's some consternation as to the full extent of Bath, because at the bottom of page 133, letter H, Mr. Sher reserved the right in higher courts to say it was wrongly decided. And indeed, ultimately, Mr. Justice Lindsay decided not to strike it out, perhaps on the basis that he wanted the matter to be considered by higher courts or leave the point open to be considered, but also because he recognised that it was dependent on the facts. If your Lordships were to look at page 143...
I mean, you're not challenging that proposition at the bottom, at page 131, at just above G, are you?
No, I say that's absolutely right. That is the full extent of the ratio above. Exactly. And 143 at letter C said that the two direct claims give rise to important matters of wide relevance. As long ago as 1911 in Bath, Lord Justice Fletcher Moulton said it would be difficult to exaggerate the importance of the questions thus raised, especially at a time when there's an increasing tendency to employ corporate bodies in the execution of trusts. It's generally found desirable in the development of the law that's developed on the basis of facts tested and found rather than upon mere pleaded assertion. Secondly, in the case in particular of the direct tort claims based on cases such as Williams and Natural Life Health Foods, has to be recognised the difference between liability being only in a company or being also, or alternatively, in its director is very much a matter of fact and degree. And for that reason, he declined, even though he thought it was actually unarguable, declined to strike it out because the facts might lead to a different conclusion. So,
I missed where you were reading from. Was it page 133?
143 more.
143, I'm sorry.
It was between C and just above letter E.
Yes, I found it. Thank you.
Can I also draw your Lordship's attention to the fact that the fifth way of putting it was piercing the corporate veil. As your Lordships can see on the previous page 142, at letter E. This was obviously considered by both the Council and Mr. Justice Lindsay as a quite separate head. And it was rejected out of hand by Mr. Justice Lindsay. But it is significant in our submission that because the respondents rely on piercing the corporate veil, they say that is what we are effectively trying to do, as part of their argument as to whether there is a direct duty between Mr. Holland and the subject companies. What we are not piercing the corporate veil, and there appears to be recognition here by Mr. Justice Lindsay that it is a wholly separate concept. So, my Lord, the other authorities take the matter no further forward. And it is therefore extreme in our submission for the respondent to suggest that it is well established in the field that directors of corporate trustees will not become liable to their beneficiaries by virtue of active participation in the management of the trust, and that there would be chaos and consternation in many jurisdictions were your lordships now to hold that honest directors of corporate directors become without more de facto directors of the subject companies. Well, the law is clearly not completely settled in this area. There's no possibility that it would lead to any sort of chaos. If your lordships were to rule that capacity is not relevant in the de facto directorship context, it will still be necessary for beneficiaries in the corporate trustee context to prove a direct fiduciary relationship between the director and the beneficiary. So the knock-on effect is not accepted, and in our submission, in any event, these authorities actually support our position. As for the other part of this objection, that this is really an attempt to circumvent the law as to accessory liability, we say that's nothing at all what it's about. If that is right, again, one could say this about any de facto director, any allegation of de facto directorship, where there is a de jure director already in place, even a natural person. You're not trying to make such a person liable as an accessory, but as primarily liable for being in breach of duty. And if your lordships were to accept this point, that this is an attempt to circumvent the Barnes and Addy dishonest assistance line of cases, then that would seriously, in my submission, undermine the whole concept of de facto directorship. One is clearly not required to prove dishonesty to prove that a person is a de facto director. If that was the case, you'd practically get no one for disqualification. You can have perfectly honest de facto and shadow directors. And what this is really designed to do is to suggest to your lordships that dishonesty, they continually emphasise that Mr. Holland was honest, and of course we accept that is so, but that in some way honesty or dishonesty is a badge of de facto directorship. It's completely not right. And it would be extremely dangerous if your lordships were to consider that it was.
The accessory liability that we see most clearly of all explained in Royal Brunei and Tan is narrower from the point of view of the claimant, in that you have to prove dishonesty, but it's much wider in that it is simply you have to prove participation as an assistant, as you say, as an accessory in the trust, whereas your submission, as I understand them, is that the de facto director really has to be the prime mover who does it,
yes.
and not simply an accessory.
Exactly. It is. We're talking about primary liability rather than accessory liability, and that is because one is looking at the person primarily in control of the companies, and so should therefore be subject to a primary duty. Which sort of leads to into the fifth objection, which is that HMRC's proposition is unworkable and would lead to anomalies. We don't accept that, of course. But the first 2 points, that directors of corporate directors will have no defence if sham is alleged and proved, and no defence if they've acted dishonestly. Well, so be it, but why should it be so limited, effectively, to having to prove dishonesty? That would mean that in any disqualification case, in order to prove de facto directorship, you would have to effectively prove dishonesty, and that can't be right. The point that they make in subparagraph 3 of paragraph 68, but where the negligence means that the corporate director has likewise acted negligently, the corporate director can be sued for it, which liability it cannot exclude, which we agree, and the corporate director will in turn be entitled to seek an indemnity from them. If the corporate director is insolvent, then its creditors can procure its liquidator to sue its directors. We make the somewhat obvious point in answer to that. Well, if the director of the corporate director is anyway going to be liable for his negligence, and for his negligence in managing and operating the subject companies, why is it necessary to go through this process of putting the corporate director into liquidation and suing him in that way? And what would happen if you have a whole string of corporate directors between the individual and the subject company? It would be a ridiculous waste of time to have to put each company into liquidation and get the liquidator to pursue each director in turn. Why not make the director liable as a de facto director? There's no reason not to. No good reason has been put forward by the respondents for not adopting our formulation.
Would subparagraph 3 be an alternative route in this case?
Conceivably. It is, but equally, there may be cases where, even though the corporate director is in breach of its duties to the composite companies, in some way that can't be translated into a breach of its director's duties to the corporate director. You see what I mean? It may be possible to proceed in this way, but why should it be necessary to do so? What good policy reason or point of principle is there in ruling out a direct action based on de facto directorship? The fact that the corporate director can itself be disqualified is also irrelevant. You want to get to the underlying individual director, the person that's caused harm. And I've already dealt with the suggestion that the corporate director can be wound up in the public interest, that also is not a sensible fallback option if we are wrong on de facto directorship. Finally, there are apparently difficulties arising from our formulation, and the suggestion is that it exposes to greater liability conscientious directors of a corporate director because they are actually doing things. To which we say, well, it's only if they misconduct themselves that they're going to be liable. Why is that an objection, a valid objection to de facto directorship in this context? And then in paragraph 71 to 72, they talk about how active one would need to be in board meetings and the like, which is all a misinterpretation of what we're saying about hydrogen. We're not saying that it depends on whether the director, the corporate director, votes one way or the other to pursue a particular course of action. It depends on what he is actually doing in the subject company. And there's no problem with judges being able to deal with that factual situation and determining the point on that basis. So, my lords, we say there's nothing in any of the respondents' so-called objections to the point of principle that we urge upon your lordships, we say it's a very simple point. It looks at the facts, ignore capacity, and do not allow individuals to legitimately limit their liability in this way. It would be an abuse of the use of corporate directors, and it would be a charter for unscrupulous individuals to organise their affairs in what would be an apparently legitimate way of limiting their liability.
Well, does that complete that chapter?
It does, my lord. So if I can move to the other grounds of appeal, can I make one preliminary point which was referred to in our case, namely on the grounds that the respondent effectively seeks to appeal or to rerun his grounds of appeal before the Court of Appeal, that under Rule 25 of the rules of the Supreme Court, those grounds can only be run without permission if they are seeking to uphold the Court of Appeal's order. If your lordships look at paragraph 124.
124 of what?
Of the case,
of your
the respondent's case.
Of the respondent's case, sorry, yes.
One can see that the only way they get home, as it were, and uphold the Court of Appeal order, assuming they don't succeed on de facto, Mr. Holland is liable, is if they establish, first of all, that fault liability is required, and secondly, that he wasn't at fault, i.e. that he acted reasonably in some way. If that is the case, then no liability in the Court of Appeal's order would be upheld. But in all other of their arguments in relation to quantum and section 212, the lordships look at paragraph 125. They're asking for an account or an assessment of damages in that eventuality. So technically, in our submission, if that is the order that they invite your lordships to make, they would have needed permission to appeal, and they haven't done so. Now, my lord, your lordships may consider, well, we've got all the arguments here, we may as well resolve them here and now, but I thought it is appropriate to bring that to your lordship's attention, because certainly under the rules, they need permission. And there may be an issue as to whether any or all of those points are sufficiently of public importance such that they would have got permission to appeal.
Is that right? I mean, I'm not saying it's wrong, but I'm surprised, because we do have to distinguish between appealing against orders and grounds, don't we? I mean, the only order that the Court of Appeal made was to dismiss the appeal and dismiss the cross-appeal. And
but I think they substituted into the... Yes, in paragraph 2 of the Court of Appeal's order, those paragraphs of that order be substituted following the said originating applications as against the first respondent be and are hereby dismissed.
yes.
So that is the order that they seek to uphold. I'm looking at Rule 25, where a respondent who wishes to argue that the order appealed from should be varied must obtain permission to cross-appeal from the court.
Well, they still want to end up with the same result of the summonses being dismissed.
Of course they do.
In the old days in the Court of Appeal, it would have been a respondent's notice to support on other grounds rather than to vary, would it not?
Well, except that they don't seek a dismissal because they seek that there be, I assume, a declaration of liability and then an assessment of damages, and then they wish to run all their arguments about
But
loss.
surely a fallback position doesn't need a cross appeal.
I leave it to your lordship.
Well,
but I mean,
I'm speaking only for myself, but others may have another view about it. I'm surprised to if that was right, there'd have to be endless applications for cross appeals, wouldn't there?
well, they certainly do seek to. They seek an assessment of damages, which wasn't ordered.
They're saying even if your appeal is successful, it should not be successful to the full extent that you're asking. I'm surprised to hear you urge on us that involves a cross appeal.
I'm not urging on your lord. I'm perfectly prepared to deal with the points, but I just thought it ought, the rules.
Are you referring to the rules which govern appeals to the Court of Appeal, or the rules which govern appeals to the Supreme Court?
The Supreme Court rules. It is actually in the White Book.
Yeah.
Well, I think rather than prolong this discussion, I mean, you've sounded a warning across Mr. Knox's bows, so to speak. I think it might be convenient if he can address us and satisfy us when he comes to this that he's entitled to do it.
Yes, I didn't want to take up time. I just thought it appropriate to draw your lordship's attention to it. These issues. There is an introduction to these issues in the respondent's case, in which they
which issues are we talking about now? We're talking about, if we look back at the statement of facts and issues, if that's convenient, where there's a list of issues set out. Which one are you addressing now? We've done one.
Well, I was going to just make some brief introductory remarks by reference to their general introduction to all these latter issues.
All right.
And then your lordship suggested that I perhaps don't need to deal with paragraph 2, which is whether liability for payment of unlawful dividends is strict or not, but to deal with the correct remedy. I think my learned friend will probably say that the one influences the other.
Yeah.
But can I just make a general point before embarking on those issues, that they paint a picture of Mr. Holland in the immediate aftermath of seeing leading counsel on the 18th of August as being faced with this terrible dilemma as to which way to go. And they say that he took the lesser of two evils in the acute circumstances that he was in. Well, we would submit that was not a real dilemma, because he had a choice between acting unlawfully and continuing paying those dividends, unlawful dividends, which was a misapplication of the company's money, until he could get the new structure up and running, or stopping paying those dividends and facing the consequences. It wasn't the lesser of two evils. He chose the unlawful course. And they do also continually emphasize that the decision was whether he should stop trading or not. In fact, the decision was whether he should stop paying dividends, unlawful dividends. Because of the way they set up this structure, it was dependent on the payment of dividends. If they had stopped paying dividends, he could still have carried on trading. He could have carried on with the employment contracts. He could have paid those on salary. If he'd done so, he may not have been in breach of any of the employment contracts that he says would have given rise to claims. there wasn't a straight choice between stopping trading or carrying on. The choice was whether to stop paying dividends or not. And in our submission, there wasn't really a choice at all. It's obvious you can't carry on paying unlawful dividends under any circumstances whatsoever. Lord Justice Rymer, in paragraph 91 of his judgment.
I'm in a bit of a muddle about what point we're actually on at the moment. Maybe it's my fault, but I mean, we're on your cross appeal, are we? I mean, on your the points 2 and 3 in paragraph 51 of your case.
No, these are definitely the respondents.
Well, this is why I'm puzzled, because I was really asking you to defer addressing the respondents' points until we've heard from Mr. Knox. And that's a neater thing to do, because Mr. Knox will lay out the arguments he wants to present, and of course you can reply. I was really hoping that you would concentrate on the points on which you lost in the Court of Appeal, to which Mr. Knox will have to reply when he
Those, as I understand it, are set out in your grounds of appeal at page 21 as heading discretion under the section 212 of the Insolvency Act and the few days grace.
Yes.
Those 2 points.
Very well. Well, I'm perfectly happy to
They're the 2 in paragraph 51, 2 and 3.
But what about the issue as to whether the liability was to restore the dividends as opposed to simply pay the high rate corporation tax? That's a point 2, isn't it?
My Lord, yes. Of course, I'm assuming, therefore, we are at this stage on the basis that your Lordships would be with us on strict liability, or Mr. Holland is liable.
Yeah.
Is liable to restore unlawful dividends, and that the usual basis for restoring, the usual remedy in an unlawful dividends case is restoration in full of those unlawful dividends.
Yes.
And one does not go into questions of loss and causation.
That's a very short point, really, isn't it?
By reference to target.
Yes.
And as your Lordships will have seen, the Court of Appeal were with us on all those issues. The Court of Appeal accepted that the usual remedy for in an unlawful dividends case is restoration to the full extent of those unlawful dividends. It's treated as a misapplication of the company's money, and the usual remedy for that breach of trust is restoration in full of the dividends. What the trial judge did is, however, limit that £1.3 million of unlawful dividends paid in the final period to, under his discretion under section 212, to the amount of high rate corporation tax that arose in that final period. And we say, quite simply, that the error that he fell into was to regard his discretion under section 212 of the Insolvency Act as allowing him to look at the loss actually suffered by HMRC as a result of the continued payment of dividends, or in fact the continued trading. The other error is looking at this matter as though it was continued trading rather than continued payment of unlawful dividends. Section 212 is well established, is a purely procedural section that enables a creditor to bring proceedings effectively on behalf of and in the name of the company. So whereas one might often get a liquidator bringing such a claim against the directors for unlawful dividends, if for whatever reason the liquidator does not wish to do so, under section 212, which has been in the Companies Act since 1865, a creditor, such as HMRC in this case, brings the claim on behalf of the company. And any money that is recovered as a result is paid back to the companies. It's paid to the companies or paid to the liquidators to distribute to the company's creditors.
Yes. Well,
So if it is the case, as it would have been, if the liquidator had brought these proceedings not under section 212, the court would have ordered the return of £1.3 million of unlawful dividends to the companies. That should be the result under section 212 in proceedings brought by HMRC.
Well, I remind myself that Lord Justice Reimer was in your favour on those points, wasn't he?
He was.
Paragraphs 103, 104, I think, make it clear that the judge's order for restitution was wrong, and he ought to follow the logic of his own findings, he said, and ordered Mr. Holland to repay the full amount of the dividend.
Exactly so. And what the trial judge had decided in the legal section of his judgment that the discretion under section 212 is somewhat limited, but then when he came to apply it at the end of his judgment, we have those rather odd paragraphs from his judgment that set out.
I don't think we need to go into this because you succeeded on that, and if that
No, we didn't succeed.
Lord Justice Ward and
Oh, I'm so sorry. I beg your pardon. Of course, yes, you're quite right. Yes, the majority the other way. I take your pardon. Yes.
But it is confusing because
Yes.
the most detailed judgment on it was certainly
That's
from
right.
Lord Justice Reimer.
Yes, I forgot.
And we say correctly,
Yes.
correctly so.
Right.
Whereas
Yes.
Lord Justice Elias, even though Lord Justice Elias agreed that the normal remedy, the usual remedy, if this case were brought by the liquidator, would be for restoration of the unlawful dividends in full,
Yes.
he thought that once one gets to section 212, the discretion was somewhat wider, and that one could look at actual loss. So even though under the normal rules, one would not look at issues of loss and causation, section 212 allows you to do so, and effectively get those arguments in through the back door. Our submission, that cannot be right. Nobody seems to have supported the way the trial judge got to that position by applying some sort of hypothetical exercise of section 727 relief. But having done so, Lord Justices Elias and Ward decided that justice, as Lord Justice Ward said in paragraph 143, one can paint justice on a broad canvas, and considered that one could look at really how much loss was suffered by HMRC and exercise the discretion in that way.
His starting point, I think, is an observation of Mr. Justice Etherton, as he was, that section 212 confers a discretion with respect to relief.
Yes.
He takes that as a start.
Is your Lordship in Lord Justice Reimer's?
No, I didn't think so. It was Lord Justice Elias I was looking at, paragraph 129.
Yes. Well, there are a number of authorities that we referred to, including Lord Justice Dillon. In which case is that?
West Mercia, is it? Paragraph 83 of your case.
I'm grateful. Yes. It seems to be accepted, even though the point has never really been that fully argued, that the discretion under section 212 is limited to the question of relief, and it's the Lockwood decision that my Lord Hope was referring to in paragraph 129 was a case where the relief was limited by reference to the actual deficiency in the companies. And indeed, that is what we sought to do in this case, and what we would submit is the extent of any discretion under section 212, that if the money, of course, unlawful dividends are paid to shareholders, it's possible that if they are recovered from directors in later proceedings, they'll go back into the company and then get redistributed to shareholders again, who benefit twice over at the expense of the directors. That would be a manifestly unfair result, would be a windfall to the shareholders. So section 212 enables that to be tempered by ordering that not the full amount be repaid. In our case, as your lordships will recall, we were seeking we were suggesting that Mr. Holland should be liable from April 2002, and that there were unlawful dividends being paid from that time until the end. A total of about £13 million worth of unlawful dividends were paid in that period. If we'd succeeded on that case, we would have accepted that we could only recover the full extent of the deficiency, which is £3.5 million. So even though the unlawful dividends were 13 million, because only 3.5 million is needed to cover the deficiency and to pay creditors, any more than that, if there was recovered any more than that, it would go back to the shareholders again.
And by deficiency, you're looking at the general body creditors.
Creditors.
Not a particular creditors.
No,
claim.
exactly, just the general body. Although I think, I understand we at the HMRC are the only creditor now in the companies.
But the step that was taken here was to look at the nature of the revenues claim,
Yes.
wasn't it? And I mean that, as I understand your case, is the error of principle, really.
That's the error of principle. Exactly so, my lord. We say that under section 212, unless there is that consequence that the money is going round in a circle and ending up in the hands of the shareholders again, that can be dealt with under the discretion. And in section 212, not to be used as a further defence to liability, as Lord Justice Rymer considered it was, nor to be used to consider how much would be appropriate in order to compensate the particular creditor bringing the proceedings. That was the error principle that the majority in the Court of Appeal fell into, and in our submission, Lord Justice Rymer was absolutely right. I'm not sure that my learned friends have really dealt with the way we put it in our case, in answer to that. They certainly refer to their case under section 212, which is that it can be used in order to reduce the amount to nil, based on HMRC's conduct and or the actual loss suffered by HMRC. But they don't really deal with our point on our appeal on section 212. And in our submission, your lordships should follow Lord Justice Rymer's carefully considered judgment in that respect and decide that the discretion is limited in the respect that I've submitted to your lordships. My lords, in relation to I'm not sure there's much more I can really say in relation to that.
Thank you very much.
In relation to the grace period, the 5-day grace period, this really is a very small issue, but it is actually an issue of jurisdiction. Under section 727 of the Companies Act, 1985, which is the section relieving directors from breach of duty if they have acted honestly and reasonably, the trial judge found that there were unlawful dividends being paid from the 18th of August because it was unreasonable for there to have been no provision from then on in relation to those, in relation to the profits being made in the companies, and therefore they were unreasonable. He necessarily found Mr. Holland to have been acting unreasonably as from that date. And your lordships can see that if you go to the trial judge's judgment, which is on page 129 of the core bundle, in that tab 4. Where he says in paragraph 269.
I'm sorry, paragraph again?
269.
Thank you.
Five lines down. However, whilst Mr. Holland plainly acted honestly at all times, I'm not satisfied that in the circumstances he acted reasonably at all times after 18th of August 2004. Or that having regard to all the circumstances of the case, he ought fairly to be excused from liability. My judgment, from after the consultation with Mr. Tallow on the 18th of August, continuing to cause the composite companies to pay dividends, and doing so without taking all appropriate advice, without properly informing himself as to the merits so far as creditors were concerned, the alternative courses of action might have been open to the composite companies, took an unacceptable risk, at least the potential expense of HMRC, with a view to seamlessly getting the new corporate structure into place. But then he said in paragraph 270, while I consider Mr. Holland is entitled to a few days' grace until, in my judgment, 23rd of August, in order to enable him to take stock, he's liable. And so he gave him an extra 5 days, which was an extra week's worth of dividends. About £150,000 worth of unlawful dividends paid in that period.
Is that under section 727 or what?
Well,
Yeah.
That's perhaps the issue. In our submission, it can't be under anything else.
Well,
There's no other discretion.
What he says under paragraph 270, isn't it? I mean, he says, in effect, he's referring to that section at the end of that paragraph. I read the two paragraphs together.
Lord Justice Reimer, at 87, thought it was on that basis. Lord Justice Reimer,
Yes.
paragraph 87.
Well, that must be right. It must be vague because there would be no discretion under section 212 to defer liability in that way, and there's no other discretion. So, but if he's already found that he was acting unreasonably from the 18th of August, there was no jurisdiction under section 727.
I wonder whether that's a fair reading of the middle of paragraph 769. I mean, we know it's a finding that he acted honestly at all times. Then he says he's not satisfied that he acted reasonably at all times after the 18th of August, but might he be saying, well, you could probably say he was acting reasonably for this period of grace, and therefore I am within section 727.
But then it depends, what was he actually doing in that period? Was he actually taking stock, or no, as Lord Justice Reimer points out, he didn't actually do anything. That he must be taken, following that decision, following the consultation with counsel, to have made a positive decision to actually carry on paying unlawful dividends, because it still went through. They didn't stop it going through. So he's decided to carry on. And as Lord Justice Reimer says in paragraph 87, all that happened was that Mr. Holland put his head into the sand and adopted a business-as-usual policy pending the putting in place of the new structure. So if he'd made arrangements to see a specialist insolvency practitioner, maybe he could be said to have been acting reasonably in that period. But there's been no finding in that respect. There's nothing that happened in that period to show that he was acting reasonably.
Well, maybe it's thought that it would have been reasonable for him to do that, and
Yeah.
it should be treated as having done that.
Well, Lord Justice Ward says that he was entitled to some time to gather his thoughts. The whole thing had been, for all reasons one would well understand, a considerable shock to him, and therefore he would be entitled to a moment or two. A week is given to just decide what the best course of conduct is to take, because he was having to readjust his position very substantially. And that's the Ward approach.
Yes.
Which is not saying, let's show what you did, it's just time to gather your thoughts.
It's reading a fair amount into what might have been the trial judge's thinking on it.
Yeah.
Because we know that obviously it was unreasonable from that point on. If they were unlawful dividends from that stage on, they were unreasonably not providing for the liability to HMRC. So that was an act of unreasonableness.
Section 7271
Yes.
says, our third line, it appears to the court here in case that officer or person is or may be liable in respect of the negligence, default, breach of duty or breach of trust, but that he has acted honestly and reasonably, and that having regard to all the circumstances of the case, he ought fairly to be excused. And as I understand your point, the only way you could let him off the days of grace was if he'd acted reasonably during that period.
And the burden would be on him to show that he did act reasonably, because the burden...
Well, leaving aside who's got the burden, the judge must conclude, this is your case, must conclude that he acted reasonably, at least during that period, and so he can be relieved of liability. So you do look at what actually happened. You don't just say, well, he was entitled to take some time to collect his thoughts together. It must be shown, and I'm not worried about the burden of proof at the moment, it must be shown that during that period he acted reasonably, and therefore Section 7271 comes into play and the judge can exercise a discretion. Is that the way you're putting it? You look puzzled, but I obviously haven't explained myself.
No, I do follow what your lordship is saying, that there has to be shown by whoever that that he acted reasonably in that period. That what he actually did in that period was reasonable, such as to entitle him to be considered for relief.
Well, I'm not sure about that, but that he has acted honestly and reasonably, and that having regard to all the circumstances, what the Act says. So the judge has got to decide, did the chap act honestly? Did he act reasonably?
Yes.
And if he concludes that during this period he did both those things, then he has the discretion to relieve him from liability.
I agree.
But your point is, well, okay, he was honest, but there's no evidence whatever to suggest that during that period he acted reasonably.
And we submit
That's
to
it
the
was
trial
reasonable
judge...
for him to have his head in his hands for those few days.
Well, I think, to be fair to the judges who are in favour of this point of view, they're not just saying that. It's not just putting your head in your hands. It's assessing the position. That's the way Lord Justice Elias puts it. Some assessment of the options must have been made, notwithstanding that, in fact, he chose the wrong course when he decided what to do. But these are big decisions that need to be made, and I don't think he would press the thing so far as to say you're not entitled to take a little time to think.
How much money is there in this point?
I'm not sure we're going to recover any money.
144,000
Yes.
according to the
That's a lot of
agreed
money.
statement of facts.
Yes, there's quite a lot of money.
So it is quite a lot of money, and we simply know that none of that taking of stock actually took place. So the short point is, and your lordships may be against me on this, is that the trial judge appeared to have found that he was not acting reasonably from the 18th of August. If that was the trial judge's finding, there was no jurisdiction under Section 727.
Yes.
If your lordships conclude that the trial judge was actually saying, I'm making a finding that he was acting reasonably for those 5 days, then...
There's what's been by at all times.
Yes, that's right.
Otherwise, I can't take it out any further.
Well, thank you very much.
I think those are the points that your lordships want me to deal with.
Yes, I think that's right. We've covered all the points on which the Court of Appeal were against you, I think, now.
That's fine, Lord.
Yes. Thank you very much indeed. Mr. Sherd, do you have anything you'd like to add? Thank you. Mr. Knox.
My Lords, the corporate director point. My Lords, can I just summarise what I say the correct analysis of this case is? I say, first of all, this. Paycheck Directors was indisputably the de jure director of the composite companies. And Mr. and Mrs. Holland were equally indisputably the de jure directors of Paycheck Directors. Secondly, all Mr. and indeed Mrs. Holland's acts in passing resolutions to declare dividends were done in their capacity as directors of Paycheck Directors. They were not acting, certainly, as de jure directors of the composite companies. It follows, therefore, that in law it was Paycheck Directors who declared the dividends in question and who is responsible to the composite companies, if there is liability at all. Further, I say it also follows that as Mr. Holland's acts were referable to his capacity as a director of Paycheck Directors, there is no basis in law for saying that he was concurrently, by virtue of those acts, a de facto director of the composite companies, or, to use the statutory phrase in section 741 of the Companies Act, 1985, or section 251 of the 1986 Act, quote, occupying the position of director. It was Paycheck Directors who occupied that position. And put in a nutshell, the crucial difference between myself and Mr. Green is this. Mr. Green says capacity is irrelevant, and I say, on the contrary, it is crucial. And that's really the question for your lordships. My lords, Mr. Green has taken you to, as it were, my objections, but I hope I will be forgiven just for reciting why I say Mr. Green's proposition is wrong. First, it ignores the scheme of the 1985 Companies Act and, importantly, reads into it a policy which is plainly not there. I will elaborate these submissions in due course. That's my first objection to Mr. Green's propositions. Secondly, I respectfully submit that Mr. Green's analysis of the cases about de facto directors, de facto managers and the like, misstates the rationale behind the doctrine of de facto directorship. It has nothing to do with getting the people with ultimate human control, even if they happen to be acting honestly in their capacity as a director of another company. It has nothing to do with that. Thirdly, it is manifest, I submit, that what the revenues argument comes to is this. You should ignore the corporate veil, even though I have neither alleged nor proved sham or fraud. You can forget about it altogether. And I submit that is exactly what you cannot do. And it is really an indirect attack on Salomon and Salomon.
But in making that submission, you are asking us to say that the corporate veil principle applies to directors. I mean, we're not looking at Mr. Holland as a shareholder, are we?
Yes, I am. I say the same position applies to directors as it does to shareholders. There is a crucial difference between the company and either its shareholders or its directors. The company has a separate legal existence. You cannot, as it were, bypass that.
It may be that the veil rather obscures the point. I mean, really, you're saying that it's separate corporate personality.
Exactly, yes. And I say, my lords, you have to respect the separate corporate personality of Paycheck Directors. That, in my submission, is the crucial point. If you do that, it follows you cannot impose a direct duty on Mr. Holland straight to the composite companies. That's the argument, but I'll come back to that. My lords, fourthly, I say Mr. Green's argument is inconsistent with what are now accepted to be, in the authorities, well-established principles from the analogous cases of directors of corporate trustees. And I submit also it is really an attempt to get round the principles governing liability for accessory liability. What Mr. Green's argument comes to is this: I don't have to show dishonesty, and therefore I can, even without showing dishonesty, the court should impose a direct duty upon Mr. Holland in respect of the said to be unlawful dividends, even though there is no dishonesty at all. I submit that's wrong. Accessory liability would be a means in, but that isn't alleged in this case. And finally, I submit that Mr. Green's proposition is indeed unworkable and leads to wholly anomalous distinctions. And my lords, Lord Justice Rymer himself in the Court of Appeal pointed out one of those. And if I can just mention it now, it does seem very odd that you have, let us say, a board of 4 directors, one of whom is a complete layabout. He does nothing. He pays no attention whatsoever to his duties. You have 3 rather incompetent ones who get, let us say, the law wrong, misunderstand the position. According to Mr. Green's analysis, the incompetent 3 directors, conscientious and competent, but let's say negligent directors, they are at risk of being held to be de facto directors of the underlying company. But the one who does absolutely nothing, pays no attention to the business at all, he's in the clear. Does, in my submission, seem a very odd consequence indeed of Mr. Green's submission. My lords, can I just now, first of all, elaborate the first point I made, namely, Mr. Green's arguments are inconsistent with the scheme of the 1985 Companies Act. My lords, can I just briefly summarise the history of the matter in this way? There are a number of company law statutes in the 19th century, but it seems that none of them made an express provision in terms for corporate directors. That is to say, none of them provided in terms that a company can be a director of another company. And it seems that the point first came up for decision in a case decided by Mr. Justice Warrington in 1907 called In Re Bulawayo. My lords, you can find that in the second bundle of authorities at tab 25.
Is it the second bundle?
Well, I think
it looks like the third.
If
it's tab 25.
Yeah, I think it should be in the second bundle, perhaps. And also, I suspect it's in the first bundle.
Well, it's in the third, I think.
Third bundle.
I think so.
I was going by the alphabetical order. Third, I do apologise. Third. Tab 25. And, my lords, if I could just take you through this case and the arguments and the way they were dealt with. You'll see that there was a petition in relation to the Bulawayo Market and Offices Company Limited, registered with Circle Capital, and so on. And then there were the Articles of Association, and what was old Article 28 provided that the directors may from time to time, and at any time appoint any persons to be managers of the company. That's all one needs to look at in that particular article. And then one drops down, after the recitation of that article, to the next page, page 459, to the paragraph near the end of the page, at meetings of the company. At meetings of the company held on January 28 and February 25, 1907, special resolutions were duly passed and confirmed with reference to the reduction of the capital of the company and to the appointment of directors. The resolution too provided for a new Article 128 that said this: management. Until otherwise determined by the company in general meeting, there shall be no directors of the company, but the control of the company and the management of its business in Bulawayo and London shall be vested in a manager or managers. And such manager or managers may exercise all powers of the company and do on behalf of the company all such acts, and so on. And then 128A, the first managers of the company shall be the Rhodesia Exploration and Development Company Limited, who shall, until directors have been appointed, hold office so long as they shall be able and willing to act, the subsequent manager, and so on. My lords, you then drop down to the final paragraph on this page to see what the petitioner's objection to this was. He says, the petitioner alleged, that the resolution was an attempt to make an improper change in the fundamental constitution of the company, so far as the entire management of his business was concerned, and to deprive the shareholders of the rights of protection given them by statute, and in fact remove the substratum of the company so far as management by directors and liabilities and responsibilities of directors were concerned. That having regard to the provisions of the Companies Act, it was contrary to public policy and to the law relating to the management of limited companies for a company constituted with a board of directors to dispense with directors and substitute a company with limited liability for individual directors with an unlimited liability, especially when shares had been subscribed for and taken by the public on the footing of regulations which provided for the management of its affairs by individual directors, and so forth. And that in the circumstances it was just and equitable that the company should be wound up. So that's the objection. And then you'll see how counsel puts it on page 461, fourth paragraph down under Hughes, QC and H. Greenwood, third paragraph down, sorry. Yes, there is no recorded instance of a limited company having been appointed sole director of another company. It's submitted that it is ultra vires the company to adopt this scheme. The criminal provisions of the Companies Act too would be rendered futile in case no individual directors were appointed. And then there's a reference to a particular section of the 1862 Act, and the answer, that section contemplates the case of a small company in which the shareholders can manage the business without delegation. Our objection is that a limited company is made sole director. Director submitted means a person and does not include a company. A limited company has neither intelligence, discretion, a capacity to be punished, nor a conscience. The persons who manage must be individuals. There is no provision which contemplates that a company can be director of another company. And then there's a further question from Mr. Justice Warrington, where he refers to other provisions. The answer is that doesn't apply. Those acts not only contemplate and refer to directors with clearly regards individuals, but would in some respects be quite unworkable if directors were not individuals. It's difficult to see how a limited company could be made liable for misfeasance under Section 10 of the Companies Act 1890, and a limited company couldn't suffer a term of imprisonment. And then over the page, you'll see third paragraph down, a limited company can no doubt hold shares in another company, no doubt about that, and then a limited company cannot furnish returns as to allotments, more objections are made, and a limited company cannot act as a director except through an agent. The Directors' Liability Act 1890 throughout speaks of directors and intending directors as persons. It's difficult to apply the words without authority and consent. And a limited company acting as director cannot be publicly examined under the relevant statutes, and other statutes would be very difficult to operate. And then, my lords, dropping down to the foot of the page, you'll see Jenkins, KC and JWM Holmes for the company and opposing friends were not called on to meet those objections. And Mr. Justice Warrington, in the second paragraph on page 463, having recited the objections, says, with respect to the contention that what is purported to be done is ultra vires, there is nothing to support it. The Act of 1862 contains certain provisions, headed provisions for the protection of members. Not a word in those provisions which in any way indicates the legislature at any time thought it was essential that there should ever be directors of a company at all, much less that the company should not be managed by a single director, who might or might not be, as the case might happen, a limited company. There is nothing, therefore, in the original Act which in any way makes it incumbent on a company either to have directors at all, or to have directors who shall be individual persons and responsible as individuals to the shareholders. So far as there's nothing material in the Act of 1862 and so on. And then with regard to the subsequent Act, no doubt there are provisions in them which assume that, according to the usual practice, as it's been developed since limited companies were known, directors would be individuals. But even in those Acts, and even though it might be difficult to fit in their provisions if the usual practice were departed from, and limited companies were appointed directors, there's nothing which I can see that indicates an enactment to the contrary, or an intention that the directors should not be limited companies. I can find, therefore, nothing in those Acts on which companies form which renders it ultra vires for the company to have another company as sole manager. So, my lords, that was how Mr. Justice Warrington dealt with the objection. Now, shortly after that, another statute, another Companies Act statute was passed, the 1908 Companies Consolidation Act. And my lord, one can pick that up in file 8. At tab 78, And, my lords, this Act doesn't make any express reference to a company as such, but what it does do, in section 72, it uses the word person. So you see, therefore, in section 72(1, a restriction on who can be appointed. A person shall not be capable of being appointed director of a company by the articles, and so on, unless certain conditions are met. And, my lords, you can see again, over the page, moving on to section 279, you can see what later became section 727, but again, if any proceeding against the director or person occupying the position of director, so again, it would seem that there is a person is to be a director, and then in the definition section, in interpretation, section 285, director is said to include, I'm looking at page 703 now, on the opposite side of the page, 2/3 of the way down, 3/4 of the way down, director includes any person occupying the position of director by whatever name called. My lords, by that stage, the Interpretation Act 1889, which we have in the Foreign Authorities bundle, at 82, it's the same bundle.
Sorry, 82 or
Tab 82 in the same bundle.
Yes.
Section 19. In this Act, and in every Act passed after the commencement of this Act, the expression person shall, unless the contrary intention appears, include any body of persons corporate or unincorporate. Now, my lords, the reason I draw attention to this coincidence is this. Bulawayo was decided in 1907. It says in pretty trenchant terms there's no reason why a company can't be a director. We then have the 1908 Act saying effectively a person can be a director, saying a person can be a director, and you interpret that in the light of the Interpretation Act. And so I submit that even in 1908, it can be said the inference can fairly be drawn that there was no objection seen by the legislature to a company being a director of another company. My lords, the first Act in which you see the word company used is the 1929 Act, which is at tab 74 in file 8. And this, in terms, envisages that a company or corporation can be a director of another company, and you get that from section 144. 144.1, in particular 144.1b, and also section 145. Thus, 144.1 provides for the keeping a register of directors, with the names of the directors, 144.1a, and then b, in the case of a corporation, its corporate name and registered or principal office, and then section 145, you see a similar provision in relation to particulars with respect to directors on the company name. Every company to which this section applies shall, in all circulars and so forth, state in legible characters with respect to every director being a corporation, the corporate name, and with respect to every director in an individual, the following particulars. And my lords, since then, successive Companies Acts provided for companies to be directors of another company. And thus, my lord, in the 1948 Companies Act, see sections 176, 178 and 201, which were the precursors to what you eventually see in the 1985 Companies Act in sections 282, 283 and 305. And my lords, can I just ask you to look at those? Again, Bundle 8, tab 76. A few pages into the tab 76, directors, every company registered on or after the 1st of November 1929 other than the private company shall have at least 2 directors. Every company registered before that date, other than the private company, shall have at least 1 director. Every private company shall have at least 1 director. And then you go to section 283, secretary. Every company shall have a secretary. The sole director shall not also be secretary. Section 283.3, I don't think adds anything, but subsection 4. No company shall, A, have as a secretary to the company a corporation, the sole director of which is a sole director of the company. B, have as sole director of the company a corporation, the sole director of which is secretary to the company. And my lords, the implication there is that, subject to those 2 restrictions, a company can indeed be the sole director of a company. And that's what is allowed for by the 1985 Act. Likewise, my lords, I think section 305, a few pages on, a provision which goes back, it seems, to the 1929 Act, section 305, directors' names on company correspondence. And subsection 1 provides the rule that directors' names must be on correspondence.
Sorry, which section?
305.
305, my lord.
305, yes.
305 in the same tab.
Yes, thank you.
Directors' names on company correspondence, and then subsection 1 provides the general rule that you must state in legible characters the name of every director of the company and so forth. And then subsection 4, for the purposes of the obligation under subsection 1 to state the name of every director of the company, a person's name means, in the case of an individual and so on, and then B, in the case of a corporation or Scottish firm, its corporate or firm name.
Subsection 3 is of interest as well.
Yes. Where a corporate, my lord, forgive me, where a corporation is an officer. Yes.
Yeah.
Now,
that deems, in those circumstances, an officer of the corporation to be an officer of the company.
Well, my lord, there you have a specific provision to deal with a problem which is obviously not in any other part of the statute. My lords, section 741 in the same Act this is really just, for good measure, the same point I made earlier in relation to previous acts. In this act, director includes any person occupying the position of director, and my lords, by now, person is defined in the 1978 Interpretation Act, section 5 in Schedule 1, as including a body corporate.
Which section is that, sorry?
In the 1978 Act, you see that at tab 83, my lord, the Interpretation Act is at 78 Interpretation Act is at tab 83. The relevant sections, my lord, if one goes to tab 83, the relevant sections are section 5.
It's really the schedule, isn't it?
Well, yes, exactly. You have to go to section 5, and then in Schedule 1, you find the relevant
page 701.
definitions. Yes. Section 5 points you to the schedule, and eventually you get to person on page 701. And my lords, likewise, the section 251 of the Insolvency Act also defines, has the same definition, I should have said, as section 741 of the Companies Act 1985. My lords, what I submit is this, just looking at the scheme of the Companies Act. Paycheck directors, and I anticipate this is common ground, but I submit it's really the crucial point. Paycheck directors must be treated as the director of the composite companies. And you cannot, on the one hand, just say, well, yes, I know they are, and then treat that, or treat paycheck directors as in some sense merely as Mr. and Mrs. Holland's or Mr. Holland's nominee, or dummy, or alias, or agent. Because the reason I say that is this: all these statutes since 1908 have been passed in the light of the conventional company law principle that recognises the separate legal existence of companies from both shareholders and their directors. And it is not, in my submission, open to the court to rewrite the law and draw the line in a different place from that which was allowed by these statutes up until 1985. My learned friend has drawn attention to the 2006 Companies Act, which now provides that in the case of every company there must be at least one human being who is a director. And one can well understand, my lords, for instance, the point doesn't now arise for decision, that let us say, in relation to such a company, there was only a corporate director and no individual director appointed. Well, my lords, one might well understand in those circumstances that the individual directors of the corporate director would be held to be de facto directors of the underlying company, merely by doing things. But, my lords, you cannot read any such policy back into the 1985 statute. My lords, it is in my submission important to look at what Salomon says about the separate legal existence of a company and the importance of, if I can put it this way, observing the lines drawn by the Companies Act, even though one might think in certain cases those lines don't quite meet the justice of the case. Because that was the problem, certainly, that was seen by the two courts below in Salomon and Salomon. My lord, Salomon is at bundle 5 of the authorities at tab 49. My lords, can I ask you just to, first of all, just go to the headnote, because the facts of the case are really quite striking. It's not, the first paragraph sets out what the ratio is, but the facts are set out in the second paragraph of the headnote. A trader, Mr. Salomon that is, sold a solvent business to a limited company, i.e. Salomon & Salomon, with a nominal capital of 40,000 shares of £1 each, the company consisting only of the vendor, his wife, a daughter and 4 sons, who subscribed for 1 share each, all the terms of sale being known to and approved by the shareholders. Part payment of the purchase money, debentures forming a floating security were issued to the vendor, that is Mr. Salomon. 20,000 shares were also issued to him and were paid out of the purchase money. These shares gave the vendor the power of outvoting the 6 other shareholders. No shares other than these 20,007 were ever issued. All the requirements of the Companies Act 1862 were complied with. The vendor was appointed managing director. Bad times came. The company was wound up, and after satisfying with the debentures, there was not enough to pay the ordinary creditors. It was held that the proceedings were not contrary to the true intent and meaning of the Companies Act 1862. The company was duly formed and registered, was not the mere alias or agent of trustee of the vendor, and he was not liable to indemnify the company against the creditor's claims, and there was no fraud on the company. My lords, what will happen is that at first instance, Mr. Justice Vaughan Williams thought that he didn't really like the look of all this, and so he said, just summarising, he said, well, Mr. Salomon controlled the company through his shareholding. He was also managing director. He basically controlled the company, and therefore I can treat him as the principal and the company as the agent, because the agent was only doing Mr. Salomon's bidding. Therefore, under usual principles of principal and agent, Mr. Salomon must indemnify his agent against the losses which it has suffered in the course of trading at his request. That was how Mr. Justice Vaughan Williams got round the problem, as he saw it. The Court of Appeal disagreed with that analysis, and what the Court of Appeal basically said is this: well, we don't think you've set up this structure in a way which was contrary to the true intent of the Companies Act. We're not going to allow this type of thing to take place at all. Therefore, we're just going to ignore the corporate structure you put in place and treat you, Mr. Salomon, as being the person responsible in any event for the trading. We don't even have to look at the principal and agent analogy. my lords, it's against those, as were, findings made by the lower courts that one has to see the comments made by the various lords. First of all, at page 31, in the speech of Lord Halsbury. And one can pick it up in the penultimate paragraph, page 31. Lindley LJ, he's talking about the Court of Appeals, affirms that there were 7 members of the company. My lords, at that point there had to be, under the Companies Act, 7 members of the company. That's the significance. But he says it is manifest that 6 of them were members simply in order to enable the 7th himself to carry on business with limited liability. The object of the whole arrangement is to do the very thing which the legislature intended not to be done. It is obvious to inquire, where is that intention of the legislature manifested in the statute? Even if we were at liberty to insert words to manifest that intention, I should have great difficulty in ascertaining what the exact intention thus imputed to the legislature is or was. In this particular case, it is the members of one family that represent all the shares, but if the supposed intention is not limited to so narrow a proposition as this, that the 7 shareholders must not be a member of one family, to what extent may influence or authority or intentional purchase of a majority among the shareholders be carried so as to bring it within the supposed prohibition? It is, of course, easy to say that it was contrary to the intention of the legislature, a proposition which, by reason of its generality, it's difficult to bring to the test. But when one seeks to put as an affirmative proposition what the thing is which the legislature has prohibited, there is, as it appears to me, an insuperable difficulty in the way of those who seek to insert by construction such a prohibition into the statute. Then, my lords, what I submit is a pertinent observation in this particular case. As one mode of testing the proposition, it would be pertinent to ask whether 2 or 3, or indeed all 7, may constitute the whole of the shareholders, whether they must be all independent of each other in the sense of each having an independent beneficial interest. And this is a question that cannot be answered by the reply that it is a matter of degree. If the legislature intended to prohibit something, you ought to know what that something is. All it has said is that 1 share is sufficient to constitute a shareholder, though the shares may be 100,000 in number. Where I am to get from the statute itself a limitation of that provision, that shareholder must be an independent and beneficially interested person. And then at page 34, again, Lord Halsbury, right at the, sorry, page, I've said page 34, 33, second paragraph, at the top of the page. My lords, the learned judges appear to me not to have been absolutely certain in their own minds whether to treat the company as a real thing or not. If it was a real thing, if it had a legal existence, and if consequently the law attributed to it certain rights and liabilities in its constitution as a company, it appears to me to follow as a consequence that it is impossible to deny the validity of the transactions into which it has entered. My lords, I say in this case. Then at the foot of the page, my lords, the truth is that the learned judges have never allowed in their own minds the proposition that the company has a real existence. They have been struck by what they have considered the inexpediency of permitting one man in influence and authority to be an influence and authority of the whole company. And assuming that such a thing could not have been intended by the legislature, they have sought various grounds upon which they might insert into the Act some prohibition of such a result. Whether such a result be right or wrong, politic or impolitic, I say with the utmost deference to the learned judges, we have nothing to do with that question if this company has been duly constituted. And whatever may be the motives of those who constitute it, I must decline to insert into the Act of Parliament limitations which are not to be found there. And then, my lords, to similar effect is...
Just before you move on, I mean, I'm just seeing the last paragraph. He moves that the judgment appealed from be reversed.
Yes.
And that was, looking back, the judgment as to whose business it really was, wasn't it? That seemed to be in the issue. I'm looking back to page 31. The judge held the business was Mr. Salomon's business, so he...
Yes.
Yeah, that was his conclusion.
That was the judgment at first instance.
Yes.
My lords, I think, I'm not sure, the Court of Appeals reasoning was different. I mean, they imposed liability upon Mr. Salomon. This was an action brought at the instant of the liquidator to the company to indemnify it in relation to its deficit.
Right. We don't have the Court of Appeal in the bundle, do we?
My lords, we don't have the Court of Appeal in the bundle, no. My lords, I think you can find out what happened in the courts below. Page 26. You'll see Mr. Justice Vaughan Williams' judgment is referred to.
Yes.
Basically, he came up with his own solution at the end of the case. You can see that from the first paragraph of page 26. And
I see, yes.
and that's why I say that it was a sort of, the judges below didn't like it. They didn't like the look of all this.
Yes.
And so Mr. Justice Vaughan Williams comes up with his solution, and then his declarations in the second paragraph, and then the Court of Appeal's solution is in the third paragraph.
Reported as Broderick and Salomon.
Ah, yes. My Lords, if I can, before I make submissions on this, can I also take you to now to page 42, I think, in the speech of Lord Herschel. Final paragraph. My Lords, can I just mention this point? Mr. Salomon was managing director of this company. And if my learned friend's distinction between shareholders and directors is a good one, that would be the answer to this case in Salomon & Salomon. Final paragraph on page 42.
Sorry, but why did you say that to me? He also held 20,000 ordinary shares in the company.
Yes, exactly, my Lord, yes.
And he also held the debentures which were secured, and
yes.
That was what gave him priority.
Yes. And my Lords, that's what
He wouldn't have been liable.
jump the queue, sorry?
Yes, but there would be no basis of liability even on the argument put to us today.
No, well, my Lords, the argument put to you today turns entirely on the difference, essentially the point that we're dealing with directors here,
yes,
rather than with shareholders. But,
exactly.
my Lords, I submit that one does have to see the strength of the point about the separate legal existence of the company, as set out in this case. My Lords, page 42, last paragraph, it's to be observed that both courts treated the company as a legal entity distinct from Salomon and the then members who composed it, and therefore as a validly constituted corporation. This is indeed necessarily involved in the judgment which declared that the company was entitled to certain rights as against Salomon. Under these circumstances, I am at a loss to understand what is meant by saying that A. Salomon & Co. Limited is but an alias for A. Salomon. It's not another name for the same person. The company's ex-hypothesi a distinct legal persona. As little am I able to adopt the view that the company was the agent of Salomon to carry on his business for him. In a popular sense, a company may in every case be said to carry on business for and on behalf of its shareholders. But this certainly does not, in point of law, constitute the relation of principal and agent between them, or render the shareholders liable to indemnify the company against the debts which it incurs. Here it's true, Salomon owned all the shares except 6, so that if the business were profitable, he would be entitled substantially to the whole of the profits. The other shareholders too are said to have been dummies, the nominees of Salomon. But when once it is conceded that they were individual members of the company distinct from Salomon, and sufficiently so to bring into existence in conjunction with him a validly constituted corporation, I'm unable to see how the facts to which I have just referred can affect the legal position of the company or give it rights as against its members which it would not otherwise possess. And then, my Lords, page 44, final paragraph. My Lords, this deals with the point my learned friend says, well, but paycheck directors, come on, it's just a worthless company and only Mr. Holland is really involved in it. Last paragraph. It is said that the responding company is a one-man company, and that in this respect it differs from such companies as those to which I've alluded. But it has often happened that a business transferred to a joint stock company has been the property of 3 or 4 persons only, and that the other subscribers of the memorandum have been clerks or other persons who possess little or no interest in the concern. I'm unable to see how it can be lawful for 3 or 4 or 6 persons to form a company for the purpose of employing their capital in trading, with the benefit of limited liability, and not for one person to do so, provided in each case the requirements of the statute have been complied with and the company has been validly constituted. How does it concern the creditor whether the capital of the company is owned by 7 persons in equal shares with the right to an equal share of the profits, or whether it almost entirely owned by one person who practically takes the whole of the profits, and so on. And then, my Lords, dropping down to the next paragraph, page 45, the Court of Appeal has declared that the formation of the respondent company and the agreement to take over the business of the appellant was a scheme contrary to the true intent and meaning of the Companies Act. I know of no means of ascertaining what is the intent and meaning of the Companies Act, except by examining its provisions and finding what regulations it has imposed as a condition of trading with limited liability. And then it carries on with the relevant provisions of the Act.
Are you passing on to look at other speeches in this case?
My Lord, I was just over the page.
Yes.
46, second paragraph down. It may be, my Lord, I submit this line of thinking I submit is important. Second paragraph down, it may be that a company constituted like that under consideration was not in the contemplation of the legislature at the time when the Act authorising limited liability was passed. That if what is possible under the enactments as they stand had been foreseen, a minimum sum would have been fixed as the least denomination of a share permissible, and it would have been made a condition that each of the 7 persons should have a substantial interest. But we have to interpret the law not to make it, and so forth. And also, the reason I emphasise these passages is what the court is saying is, well, it may well be that if the legislature had thought about certain things which had been done pursuant to the Companies Act, he might well have put a provision in there to deal with it. And my Lord, that I submit is what Mr. Green is really saying in this case. He's saying that the effect of his argument, I submit, is undoubtedly this. Where a company is a director of another company, there is always one human being who is a de facto director. That's the effect of his argument.
I imagine you would probably say that the submissions of the respondents in Salomon and Salomon that we can find at page 28 are echoed in your opponent's submissions.
Well, my Lord, what I say, roughly, I say this. Mr. Green is running the same points, I'm conscious of the time, my Lord, is running the same points as the objectors in Reba Ohio, and he's running the same points as the respondent in Salomon and Salomon. Really what he's saying is you can't let this type of thing happen. So you find the person on whom directorial liability can be fixed as a human being. Otherwise, you've got all sorts of problems. And I submit...
You're not going to Lord Macnaghten, are you?
There's
an interesting passage in the middle of page 53 of Lord Macnaghten, who had a very keen grasp of commercial realities, when he says the whole trouble is down to floating charges and they really ought to change the law.
Yes.
And of course later on they did change the law.
Well, very short there, yes.
The passage beginning for such a catastrophe and ending up, and a great scandal it is.
It is too, yes. Well, my Lord, exactly. My Lord, that was what, I think one gets the impression, that is what the courts below found so difficult in the conduct of Mr. Salomon. Namely, here he is, he's got his debentures, he comes in as a preferential creditor, and he says goodbye to all the others, the business having failed. And that was the problem. My Lord, shortly after that problem was rectified, I think, in the early 1900s.
Partially rectified, yes.
My Lord,
Shall we come back and look at this case a bit more tomorrow morning? 10 o'clock then. Thank you.